This is part 47 as far as our lecture series is concerned, and in this part we shall be dealing with chapter 31 of the Criminal Procedure Code, which deals with transfer of criminal cases, and for that we will refer to right from section 406 up to section 412 of the Criminal Procedure Code. Section 406 deals with power of Supreme Court to transfer cases and appeals, and it says, whenever it is made to appear to the Supreme Court that an order under this section is expedient for the ends of justice, it may direct that any particular case or appeal be transferred from one high court to another high court, or from a criminal court subordinate to one high court to another criminal court of equal or superior jurisdiction subordinate to another high court. Subclause 2 says, the Supreme Court may act under this section only on the application of the Attorney General of India or of a party interested, and every such application shall be made by motion, which shall, except when the applicant is the Attorney General of India or the Advocate General of the state, be supported by an affidavit or affirmation. Subclause 3 says, where any application for the exercise of the powers conferred by this section is dismissed, the Supreme Court may, if it is of opinion that the application was frivolous or vexatious, order the applicant to pay by way of compensation to any person who has opposed the application, and such sum not exceeding 1,000 rupees as it may consider appropriate in the circumstances of the case. So this is a power of transfer which is exercised by the Supreme Court as far as cases and appeals are concerned. With this now, the next section, namely section 407, deals with power of High Court to transfer cases and appeals. And subclause 1 says, whenever it is made to appear to the High Court, small a, that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or b, that some question of law of unusual difficulty is likely to arise, or small c, that an order under this section is required by any provision of this code or will tend to the general convenience of the parties or witnesses, or is expedient for the ends of justice. It may order 1. That any offence be inquired into or tried by any court not qualified under section 175 to 184, 85 both inclusive, but in other respects competent to inquire into or try such offence. Secondly, that any particular case or appeal or class of cases or appeals be transferred from a criminal court subordinate to its authority to any other such criminal court of equal or superior jurisdiction. Thirdly, that any particular case be committed for trial to a court of session. And lastly, that any particular case or appeal be transferred to and tried before itself. Subclause 2 says, the High Court may act either on the report of the lower court or on the application of a party interested or on its own initiative, provided that no application shall lie to the High Court for transferring a case from one criminal court to another criminal court in the same sessions division, unless an application for such transfer had been made to the session judge and rejected by him. Subclause 3 says, every application for an order under subsection 1 shall be made by motion, which shall, except when the applicant is the Advocate General of the state, be supported by affidavit or affirmation. Subclause 4 says, when as such an application is made by an accused person, the High Court may direct him to execute a bond with or without sureties for the payment of any compensation which the High Court may award under subsection 7 Subclause 5 says, every accused person making such application shall give to the public prosecutor notice in writing of the application together with a copy of the grounds on which it is made, and no order shall be made on the merits of the application unless at least 24 hours have elapsed between giving of such notice and the hearing of the application. Subclause 6 says, where the application is for the transfer of a case or appeal from any subordinate court, the High Court may, if it is satisfied that it is necessary so to do in the interest of justice, order that, pending the disposal of the application, the proceedings in subordinate court shall be stayed on such terms as the High Court may think fit to impose, provided that such stay shall not affect the subordinate court's power of remand under section 309. Subclause 47 says, where an application for an order under subsection 1 is dismissed, the High Court may, if it is of opinion that the application was frivolous or vexatious, order the applicant to pay by way of compensation to any person who has opposed the application such sum not exceeding 1000 rupees as it may consider proper in the circumstances of the case. Subclause 8 says, when the High Court orders under subsection 1 that a case be transferred from any court for trial before itself, it shall observe in such trial the same procedure which the court would have observed if the case had been so transferred, if the case had not been so transferred. And last clause 9 says, nothing in this section shall be deemed to affect any order of government under section 197 of the Criminal Procedure Code. With this now, section 408 deals with power of sessions judge to transfer cases and appeals, and its subclause 1 says, whenever it is made to appear to a sessions judge that an order under this subsection is expedient for the ends of justice, he may order that any particular case be transferred from one criminal court to another criminal court in his sessions division. Subclause 2 says, the session judge may act either on the report of the lower court or on the application of a party interested or on his own initiative. Subclause 3 says, the provisions of subsection 3, 4, 5, 6 and 7 and 9 of section 407 shall apply in relation to an application to the session judge for an order under subsection 1 as they apply in relation to an application to the High Court for an order under subsection 1 of section 407, except that subsection 7 of that section shall so apply as if for the words 1000 rupees occurring therein, the words 250 rupees were substituted. Section 409 deals with withdrawal of cases and appeals by sessions judges, and it says, a sessions judge may withdraw any case or appeal from or recall any case or appeal which he has made over to any assistant session judge or chief judicial magistrate subordinate to him. Subclause 2 says, at any time before the trial of the case or the hearing of the appeal has commenced before the additional session judge, a session judge may recall any case or appeal which he has made over to any additional session judge. Subclause 3 says, where a session judge withdraws or recalls a case or appeal under subsection 1 or subsection 3, he may either try the case in his own court or hear the appeal himself or make it over in accordance with the provisions of this code to another court for trial or hearing as the case may be. Section 410 deals with withdrawal of cases by judicial magistrate, and it says any chief judicial magistrate may withdraw any case from or recall any case which he has made over to any magistrate subordinate to him, and may inquire into or try such case himself, or refer it for inquiry or trial to any other such magistrate competent to inquire into or try the same. Subclause 2 says any judicial magistrate may recall any case made over to him under subsection 2 of section 192 to any other magistrate, and may inquire into or try such case himself. Section 411 deals with making over or withdrawal of cases by executive magistrate, and it says any district magistrate or subdivisional magistrate may make over for disposal any proceeding which has been started before him to any magistrate subordinate to him, withdraw any case from or recall any case which he has made over to any magistrate subordinate to him, and dispose of such proceeding himself, or to refer it for disposal of any other magistrate. And lastly, section 412 says a sessions judge or magistrate making an order under section 408, section 409, section 410 or section 411 shall record his reasons for making it. So this is regarding transfer of criminal cases as far as the Criminal Procedure Code is concerned. With this now, the judgment is passed by the court, and now the sentence that is inflicted by the court of law is required. Sentence is pronounced by the judge, yes, no doubt about it, but execution of it is by the government, and hence the next chapter, right from section 413 up to section 435, namely chapter number 32, with which we intend to do as far as our next series of lectures is concerned, where we shall be dealing with execution, suspension, remission and commutation of the sentences. So in order to understand execution, suspension, remission and commutation of sentences, as I have told you, we shall be dealing right from section 413 up to section 435 of the Criminal Procedure Code. Now, as far as death sentence is concerned, that is for the purpose of execution, we shall be dealing right from section 413 up to section 416 of this chapter is concerned. As far as execution of imprisonment is concerned, we shall be dealing right from section 417 up to section 420 is concerned. Regarding levy of fine, we shall be dealing right from section 421 up to section 424 of the Criminal Procedure Code. Right from section 425 up to section 431 are the sections which are general provisions regarding execution with which we shall be dealing. And then once we start right from section 432 up to section 435, this is the part of the chapter which deals with suspension, remission and commutation of sentences. But then this is the part of the chapter with which we shall be dealing as far as our next, in the next part as far as our series of lectures is concerned.